Welcome and thank you for joining Session 1 of Seyfarth's Commercial Litigation Outlook webinar series, Charting the Course, AI's Influence on Legal Practice and IP Protection. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Ken Wilton. Ken, you may begin.
Thank you. Appreciate that. First, we thought we'd start with some goofy pictures. Since this is AI, we thought we'd use something akin to AI to create those photographs. As a preliminary, for those who logging in, I know you're aware of our commercial outlook that we prepare every year, and this webinar today is intended to cover two of those chapters. And an announcement at the beginning, because I'm not sure what's going to happen by the end. We've got two more coming up. One is on April 11th, which will be discussing navigating restrictive covenants. And then on May 2nd, we'll have insights and predictions on litigation trends in 2024. So for today, topic is AI, which I think is now a requirement for all CLE in California, is that everything has to cover AI in some fashion. In preparation for this, I did a quick survey of attorneys in our offices here just to see how many folks are actually using AI. And the numbers are around 60% right now. So it seems like we're kind of at the beginning of this curve, which is a good time to be talking about the topics that we're talking about today. We prepared 16 questions, which we will not get to 16 questions because there is 1 hour of time, which is now down to 58 minutes, but we'll do our best. So for the beginning of this, we're going to have Rebecca Woods and Owen Wolf are going to talk about some topics generally related to the use of AI in our practices. So why don't we do that? We'll open up. My first question is, should lawyers be using AI in their practices? Rebecca?
Yes, they should be. Right now, the reality is that the use cases, the use cases proliferate, and those are the ways in which you might use AI. The problem is the accessibility and the development of software to use AI reasonably. We have internally, and I think standard access to certain things like Copilot through Microsoft, Westlaw's Edge or Precision for legal research. There are a variety of document review platforms that are using AI, some to come, like Relativity, which most people have, is going to be launching its AI functionality by the end of the year. So there are lots of use cases available and some access to programs. There's free ChatGPT 4, and well, I think 4 is not free, but there are lots of large language models, LLMs, that are available to use for brainstorming and the like. So there's the kind of the what, but I actually think the biggest point for lawyers right now, until we see like the real inflection point of lots and lots of AI being available, I think the important part is for lawyers to get fluency and comfort in AI. Even at its most pedestrian level, to learn how to do, for example, prompting, effective prompting. So when you're on a Copilot or a ChatGPT or a Llama or whatever you have access to, you know how to form prompts so you get something actually useful and actionable back. And then further, that you just stay abreast and learn about what's to come, because we are definitely at the beginning of a wave. We're at the beginning. I think there are a lot of naysayers out there. Oh, it's not really happening, or it's not helping me, or it's not doing anything functional right now. And I think there's some credence to that, but it's going to change. And we're at the beginning part of this wave, and we all need to jump on it.
And Owen, I agree with that, by the way. And I think every time we have the advent of new technology, there's always the early adopters and the rest of the gang, and then the late adopters, and we're sort of on the early stage right now. So we're not quite sure what it will do, but we're going to find out. And Owen, have you given some thoughts on what the key risks might be with regard to the use of AI?
Yeah, absolutely. And, for all the benefits that AI might potentially bring to our practices, there certainly are a lot of risks. One of the big ones is making sure that information that you put into a generative AI program in particular stays confidential. So if it's a public program like ChatGPT, if you're putting in privileged information or confidential information or trade secret information, really putting that information at risk of exposure. Nobody wants that, so have to take great care that you're either using a program where the information that you input is going to stay confidential, or again, if you're using a public program like ChatGPT, that you're not putting in anything that you don't want disclosed to the broader public. Then one of the other big risks that I see, and many others see, is the prospect of hallucinations, as they're called, or just AI giving bad information in response to your requests of it. I think probably most folks on this call, they've hopefully heard about the horror story from last year where there were some lawyers who asked ChatGPT to pull up some court cases, and ChatGPT did so, but it turned out the court cases weren't real, but they went into the court papers and the lawyers got sanctioned. So I think those are risks that everybody wants to watch out for and make sure that they are sort of performing oversight of anything that they're getting from AI to make sure that the information is good, they're not getting fake cases, and they're not putting anything out there that they don't want the general public to see.
So you're saying we shouldn't use it for legal research?
Well, I can't say that I've tried every AI program out there. I certainly haven't, but at least the ones that I've had experience with, they don't seem to be quite ready for prime time when it comes to legal research. Setting aside the issue of fake cases, they're just not seeming to be able to find cases in a way that a lawyer is able to, frankly. Just as an example, my experience has been that if you ask an AI program to find cases that involve, just as an example, a truck speeding down the highway at 70 miles an hour, the results that come back will say, here are cases involving a truck going at 70 miles an hour, but you open all the cases it sent you, and they're real cases, but they involve motorcycles parked in a parking lot. So they're just not exactly what you're looking for. So I don't think that, again, even setting aside the fake case issue, it hasn't reached the point where it can really accurately do legal research in the same way that a lawyer can. We may get there at some point, though.
It's interesting that you say that because, as you know, within the firm, we've tested a few AI engines in a closed setting, which I encourage everybody to learn about AI in that sense, like how it works and what the difference is between an open system and a closed system. But one of them, it was taught on case law, and one of the advantages I found of the AI is you could ask iterative questions. You could ask a question, you may get a broad answer. You say, well, wait a minute, what about just the Ninth Circuit? And in sort of natural speech, you can lead down to maybe a few cases that actually are on point. I agree with you. I think it's still in the early stages, but I think it will be a tool that we can all use that will allow us to get to answers that used to take these weird structured searches, Boolean searches and such, will now become natural language searches.
Let me just jump in on that. I actually disagree with Owen a little bit on this. I was talking with a client about an issue, and he had access to CoCounsel, which is CaseText's legal research tool. And he typed in his question, and up came an answer, and he sent it to me. And I have to tell you, it was kind of right. Now, would I rely upon that in writing a brief or in arguing to a judge or even answering a client's question? No. But is it a really good start, especially for younger associates? Yes. And it will get better. To Owen's point, it will get better.
And you just touched on something, Rebecca. Yesterday, I heard a panel of judges talking about about generative AI, and one of them very frankly said he had no idea what it was, which reminded me of the, since I've been doing this a while, the advent of the internet as we know it back in the late 90s, and every brief had to open up with a description of what is the internet. How do we get past the distrust by the courts in new technology such as this? So, because some of these courts have rules that say
we get rid of all the old judges. I'm joking.
Thank you for listening today. No, in all seriousness, there's a certain distrust among, it's somewhat generational, it's somewhat just technology, tech savvy. And some courts now have rules that you can't use AI. or you have to disclose that you used AI in the context of what you're submitting. Any thoughts on how we get past that sort of initial distrust of, well, you used AI, I don't trust everything else you've written. How do we get past that?
I mean, I think it's a lot time and use, right? You may be old enough, Ken, to remember that with the advent of email, people flipped out, and there's huge consternation around the use of email, how unsafe it was, and how lawyers would never communicate that way. And that was quickly eclipsed by reality and the speed. And I think that we're really at an early stage, but here's the trick about this technology. We're at an early stage, but things change fast. And I think courts will have no real leg to stand on if they say you can't use AI. I think it's fair for now to disclose how you're using AI, although I have to say, the case that Owen referenced, the fake cases, the current platforms that are doing legal research are, at least they say, you're not going to get hallucinations on cases being created anymore. I think that's a fairly easy solution. It's been implemented, and that's where this iterative feedback loop of, oh, it doesn't work well, and then bam, it's going to work better, is, Moore's law is out the window. I think we've got such a fast cycle of learning and improvement and learning and improvement. And after all, that's kind of what Gen AI is by itself. So that's a long way of saying I think that, yes, there's reticence now, but I am pretty confident that within a handful of years, all but the most troglodyte judge will be comfortable with the use of AI.
This is being recorded, just thought I'd remind you.
I didn't name anybody.
No, let me move into a sort of slightly different area, because we're sort of talking about the outside counsel view of Gen AI. What about in-house counsel? What should they be concerned about? Either one of you.
Yes. So this is, I'm sorry, Owen, I'm going to jump in on in-house counsel for a moment, because actually I'm pretty excited about how in-house counsel should be thinking about and using AI. First, in terms of thinking about it, I think I want to encourage in-house counsel to think big and realistic, and at the same time manage expectations, because while the technology is still at a fairly early phase, your business partners are using it right now. I have no doubt about that. In fact, we're clearly finding that the business persons are using Gen AI and other versions of machine learning, which is a version of AI, and the lawyers are well behind and trying to understand what the risks are. So jump in quickly, because things are changing and you don't want to be left behind. At the same time, I think in-house counsel need to manage this natural fear of the unknown. There's a huge amount of concern around people losing their jobs. I think that, the legal media and the media in general, they're all chasing after clicks and eyeballs. And so there's a lot of talk about how people are going to lose their jobs. And, maybe Skynet will become active someday. But for right now, what AI will do is it does tasks for humans. Now, if your job is solely task-based, then you need to be worried. But if your job is bigger than simple tasks, then I think you're okay. And so as a leader of an in-house department, what I would do is think about change management. I would encourage people to engage with how would you want to use AI? Even if there's not a solution now, there could be a solution. So those are kind of the soft parts. In terms of practical what to do, I actually take inspiration from the U.S. government last fall issued, I guess it was Executive Order 14110, which is the guidelines on safe, secure, and trustworthy AI. It's a behemoth. It is quite a read, but it maps out considerations that U.S. agencies need to undertake when they're developing and using AI and authorizing its use. And so if you have like a chief AI or artificial intelligence guru in your legal team, maybe it's not a dedicated role, but it's somebody who's kind of the point person for a number of functions that legal departments will have to address. So for example, compliance. How can we use AI to make sure that we're in compliance with all the laws and regs that we have? How do we ensure that our use of AI itself complies with laws and regs? What is the current technology? Even within this law firm, and we have legal tech gurus, we're all drowning in who are the vendors and what are the new systems that are available? How can they be used? And they can get very technical on the security, the latency of the system, the benchmarking parameters. So having somebody within either in-house or outside counsel who's, geeky on this stuff be able to provide guidance on, well, you might want to consider these programs, or here's the kind of things that you want to consider. That person also needs to be concerned about the threat landscape. What kind of lawsuits could be coming at you for your use of AI. This is becoming particularly acute, I think, in the employment space, where the use of AI is posing risks on inherent and embedded bias. And I think you also want to use AI to liaise with outside counsel. I have a whole spiel on that. So that's maybe mimicking either internally or externally those kind of key guidelines that are provided by the U.S., that the U.S. has provided to its regulatory agencies. And then two other things real quick. I think you want to train your in-house counsel on how to use AI or have them be trained. I think, again, the big ingredient there is helping to breed a culture of curiosity and trust. Curiosity in terms of what's out there and how can it make me be a better partner to my business people, and how can it make me be a better lawyer, and trust that you're not going to lose your job. You need to be really engaged, and you can use it to brainstorm and kind of be a better contributor to your legal department. And then I guess on the final note, I would say for in-house use is being able to thinking about uses of AI to optimize your use of outside counsel. So when I think about use of outside counsel, there's some typical pain points, right? There's information flow. What's going on in this case? Who's doing what? There's exposure and case assessment. There's case management and efficiency issues. And there's budgeting. What was your budget, and was it good? And how are you tracking to your budget? I think AI can currently help with some of that, and there will be coming AI programming that can further help with that. And so I think in-house lawyers would be, I don't think outside counsel, unfortunately, are going to be replaced in any near-term future. And so using AI to optimize how outside counsel augments your business is going to be an important function for AI.
Let me ask a question of Owen in terms of, those are very good points. How do you get people familiar with AI? How do you start that training process?
Yeah, I mean, that's a great question. I think it's a matter, as Rebecca's touched on, of getting people curious, getting them out there, trying these programs for themselves, seeing what they're all about, understanding what they can do. And I think just as importantly, what they can't do, either currently or, where the business has decided the risks of doing it are just too high for what they're willing to accept. And I think getting that training and making sure that folks are comfortable with the technology is really going to be critical there. As you said, there were a lot of people who are concerned about or naysayers about the internet, email, all those sorts of things, but it's become integrated into our daily lives. Everybody's pretty comfortable with that now. And I think we're going to get there with AI too. It's just going to be a matter of time and use.
And something else Rebecca touched on, the regulatory environment. Where do you see that going after the executive order and the EU AI Act? Do you think there's going to be more regulatory oversight over the use of AI, particularly in the legal profession, or how do you see it playing out?
Well, I don't think we're going to see any binding regulatory action, at least this year. Just the reality of the current political climate and the fact that we're in an election year, certainly at the federal level, not expecting anything major, although the executive order that Rebecca mentioned, it does direct a number of federal agencies that affect a wide swath of areas, finance, healthcare, intellectual property, everything in between, for those agencies to issue their own guidance. So we should expect to see that coming out in the next few months or so, and that may provide some pointers and tips about what federal agencies are thinking about, and maybe best practices in particular industries. Where I do think that we're going to see some gap filling is going to be at the state and the local level. And in particular, we're seeing a lot of states and local governments issue AI-related laws about particular sort of narrow subject areas. So, other than the judges that you mentioned, we haven't really seen a whole lot that's specifically targeted at lawyers or the legal profession yet, but we are seeing laws coming out in other areas that lawyers need to be aware of and taking into account. Here in New York City, where I am, there's a law on the books that relates to the use of AI in hiring and requires employers to do an audit if they're using AI programs to sort of sift through candidates or that sort of thing to make sure that there isn't any bias going on there. It's also been in the news quite a bit recently that a number of states, I think we're up to about 10 now, including New York and California and others, have put into effect laws that relate to deep fakes, which are videos or images or audio that purports to depict the person, a real life person who didn't actually pose for the photograph or appear in the video or say the things in the audio. It's been a big problem. There was an incident recently in the news quite a bit about a deep fake involving Taylor Swift that apparently has spurred a number of other state legislatures into action. So I think we're going to see a lot more laws at the state and local level. And then finally, real quick, just because you mentioned it, there's also the EU AI Act, which hasn't gone into effect yet, but that legislative process is moving along at a fairly quick speed for the EU. And the text of that act is online. It's something that companies operating in Europe should be aware of and should be paying attention to. And it has sort of tiers of regulation depending on how the EU classifies the risk of the particular AI program. So that's going to be really important for companies that operate in the EU in particular.
It strikes me as supporting the notion that Rebecca mentioned, having a chief AI person or some point person for in-house counsel to be tracking this, because it's coming from very, very many different directions. Another sort of related question, how do you develop use cases for AI? I mean, we know what it is, and I think later on, we'll talk about a few ways in which we're using it now. But if you're in-house, how do you go about trying to find tasks that might be related to AI, might be supported by Gen AI or improved by Gen AI? Any thoughts on that?
Well, I think, again, creating a culture of curiosity and brainstorming as a group. We've done so in my litigation group. And I think the first step is to think of what tasks do I do? A couple of years ago, our firm was big on project management, and I helped to create the process map for commercial litigation. And so what we did was we chunked down each of these steps that you go through when you litigate a case, from intake and case assessment and depositions and all the little steps in between. And it was an interesting practice, but I would actually, we're going through again and looking at that. What are the tasks that are within that functionality? And then how can they be automated? Automation is a very simple version of AI, or how can they be otherwise augmented with AI? So I think an in-house legal department could encourage its team members, what are the tasks that we're doing and how can we use AI to expedite them? And, I think where the real traction is going to be is how are the ways in which we are or are not collaborating with our business partners in a way that cause pain points for our business partners, and how are those amenable to an AI application?
Owen, any thoughts on that?
Yeah, the only thing that I think I'd add is just underscore Rebecca's last point about having that dialogue between the business and in-house legal teams and making sure that all the stakeholders within a company are aligned in terms of what the risks are and what risks they're willing to accept. And that, I think, can help guide how AI is put into place and how it's used on a daily basis in a way that's consistent with that risk tolerance and implements it in a way that's going to be successful for everybody involved.
Let me ask you both this question. Are you using AI today in your practice? Well, actually, it's
Go ahead, Owen.
Two different questions. Are you using AI, Gen AI, A? If so, are you using it in your practice or in some other fashion?
Go ahead, Owen.
So I am not using generative AI to clarify, separate from other forms of AI, I'm not using it yet in my practice for clients. So I have used it in general, and in particular, I found it to be incredibly helpful when I'm drafting blog posts or articles about legal topics in terms of trying to come up with a catchy title or summarize sort of complicated legal concepts in simple terms. And I think that as Gen AI gets better and better, and we start working with closed systems where we don't have to worry about potentially confidential information getting out there, that's going to be a powerful use of AI for lawyers in terms of brainstorming and finding the right words and that sort of thing. So looking forward to that. I'm just not quite there yet in terms of client work, but imagine going to start getting there pretty soon.
Rebecca?
So, in some ways, so I love this idea of AI. I don't know why it's so captivated me. And I think it's a little bit like about damn time that we get to use some cool tools. We do have tools within the firm that we have access to: Copilot, Practical Law AI, Westlaw Edge. I use all of those. I try and test the boundaries of what they're actually yielding for me. So far, it's a little bit better. I'm doing a panel in a week from now, and I asked it come up with questions for me. So it's also helping with the softer side of the legal practice. I do want to say that if you ever see a blog post from me or a LinkedIn post, I wrote it. I'm not yielding to AI on that. But, kind of like practicing what I preach, I also have a lot of ideas on how I want to use AI, and it's not there yet, but it will be. And, like, for example, I want an AI that will collate all of the documents in a case, the testimony in the case, the legal issues at play, the law at play, and help me synthesize quantitative risk assessments, help me generate briefs, at least good working first drafts, and help me provide reports to my clients. I want a robust budgeting tool. We have a ton of big data available to us on how much things cost to do. Our clients have a ton through all their billing systems. Why don't we have access to those? And I'm sure AI could come up with thoughtful budgeting parameters for, you have a summary judgment motion in this kind of case coming up. Well, here's what what the system says would be roughly your budget. Then it could track you in real time and allow you to become a more efficient and thoughtful lawyer. So that's just an example of the kinds of creative thinking that I think lawyers of all kinds should be doing, because those systems will become available, and we should be, when they are, and if we can pay for them, that's a big issue. We should be willing to jump on them and use them.
And you just touched on something, and then I'm going to change questions a little bit. There was a survey done, I think, by Citigroup, I don't know, in the last month or so, of law firm leaders and in-house counsel. 53% thought there'd be a reduction in force of lawyers in the next 5 to 10 years. And I think what you just described, Rebecca, is one of the reasons why that fear is there, is because what you described is a thing that you would normally, to do a case assessment, you've had 3 or 4 people looking at documents and doing that kind of analysis in a manual fashion. If you can put everything into a machine and ask iterative questions, do you need those other people? And I'm just going to let that one float out there, and maybe we'll get back to it at the end of the session. Now, at this point, let me transition a little bit to the IP side, since we have about a half hour left. Thank you, Rebecca and Owen. You'll be back. Don't worry. You're not being sent to purgatory. I'm now joined by my partners, Puya Parto-Navid and Lauren Gregory-Leipold, who will be talking to us about some of the AI implications related to intellectual property, which is also top of mind. It's part of our commercial litigation outlook for 2024. And why don't I'm going to sort of level set where we start with this, because generally AI issues are coming up in the copyright and patent context. They're not coming up in trademarks, because trademarks really are not AI driven as much. And as we all know, it's our Constitution that gives us copyright and patent. And that the purpose of it is to promote the progress of the arts, the science and useful arts. So with that kind of basis, let's start with challenges in patenting AI inventions. What are those, Puya? And what is an AI invention? I've used the term, but what would you interpret that to mean? You're on mute, my friend. Let me use this as an example that, okay, we've been using technology such as this for about 4 years.
Yes.
And we're still getting used to it. And I think that's going to be the pattern for AI as well. It's going to be,
Well,
you know, the first time you use it, it may not work. Don't give up. Keep trying. So go ahead. I'm sorry.
an AI invention could be an AI detecting that you're speaking on a WebEx conference and you're on mute and automatically unmuting you. That's an AI invention. Other AI inventions deal with, the actual algorithms of the AI model. So there's two types. One is applying AI to an existing technology, and one is the guts of the AI system. The guts of the AI system, the algorithms are non-patentable. So you have to show how that algorithm is improving the AI system. Applying an AI system or an AI model to an existing technology, you're going to run into some challenges, which is essentially it could be deemed as organizing human activity or a mental process, which those areas are not patentable either under Section 101. So what it comes down to is, and this is a problem we face with many clients where they're like, we have a staffing model and we've been doing it by hand, and now we want to have AI do it and it's just going to make it faster. Unfortunately, those systems aren't patentable. You have to show how it's a technical improvement to a technical problem. And it's the same analysis that goes on with Section 101 or Alice rejections. So that's what it comes down to. Are you does the problem exist in technology, and are you improving it?
How do you control the inventive process, like within a company particularly, so that you may be using AI, but your resulting invention is something that would be patentable?
It comes down to realizing that that's the core of it, is framing it into, here's a problem that exists because of technology. For example, what just happened now. The problem is we're on WebEx or we're on a Zoom call, video conference, and we need a way to unmute you when you're talking, automatically unmute you. Another example is navigation software. Navigation software, if the software is not accurate and you find a way to improve the accuracy, that's a technical solution to a technical problem. Another issue is, for example, if you're cashing checks via your phone and the phone isn't accurately detecting the signature on the check, the old way is you taking it to the bank and the teller is depositing your check. Now we have a new technology, and the problem is the technology isn't detecting the handwritten signature. So that's a technical problem, and you're creating a technical solution. So when you understand that that's the basis for getting a patent in these types of systems, then it's easy to say, okay, these are the solutions. These are the problems that we found. Here are our solutions to it. That's the mindset. When you go in with that mindset, it's easier to find your AI inventions.
Do you need to keep track of that for some purpose, for prosecuting the patent or whatever it may be? Do you need to be tracking, like, the technical problem? Do you need to write it down, have it somewhere? Do you need to track how you're using AI in the process of developing your invention?
It's a good idea. I mean, that's if you are focused on protecting your inventions, or if you have a mindset on patenting technology, you need to have a talk with your engineers, your product management teams, and say, this is what we want you guys to focus on. Write them down, and then we can have a meeting with our patent attorney. We can have a meeting internally with our in-house counsel, and we can go through and see which ones of these we actually want to target, because patents aren't cheap. So you're gonna have budget considerations, but those are the talks that need to go on. Is let's focus on our IP and let's see what is protectable. And if you start early and you can list them out, then you can have meetings down the road with your IP attorney, with your in-house counsel, or whoever else is involved in the inventive process.
And turning to Lauren for a second, on the copyright side, is there sort of a similar record-keeping kind of idea you might need to face if you've got partially AI-created content?
Yeah, that's an important point. And first of all, let me just stop and say I'm so glad that you opened this segment by talking about the copyright clause and the difference between copyright and trademark. People, I suppose the uninitiated, I would say, often conflate the two. I just listened to a New York Times podcast this morning that confused copyright and trademark. And to be clear, trademark law doesn't matter who invented it, how they invented it. It matters that, you know, if a trademark is out there, if it's confusingly similar and it's confusing the public, that's going to be the problem. Copyright talks about inventorship and creativity. And as you mentioned, it's designed to promote this creative process and provide some guardrails around, you know, allowing the author of that work to be the gatekeeper in the dissemination, the monetization of that work. And so, you know, AI tools are sort of another way to continue to create that kind of content and can be used in conjunction with a human to create new content. The problem with that, unfortunately, is that the Copyright Office has taken really a pretty strict stance against any sort of protection for AI generated works. The reason for that, again, goes back to that copyright clause, that the idea is that we are protecting human innovation. And so this all started about a year ago. In March of 2023, the Copyright Office issued some guidance in the Federal Register that was prompted, quite honestly, by people filing applications for copyrights and obtaining a registration for AI generated works and then bragging about it. And the Copyright Office took it upon itself to say, whoa, 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 wait a second. This is not what copyright law is designed to protect. And so they went back and issued this guidance, which says you better delineate between the human generated portion and the AI generated portion, because the AI generated portion is not copyrightable. And they go back to case law that was decided in the 1800s, back when portrait artists were afraid that photography was going to kill their art. And this is the same sort of thing, where it's this new technological tool that is coming into play. And so the question is, how does that interface with copyright law? It's you know, constantly been a problem. There's always this tension. I mean, when the internet came out, that the Digital Millennium Copyright Act was passed to address some of that. So this is not a new issue in that respect. But the current stance is that human creativity is protectable, AI generated content is not.
So how do you delineate between the two? Because it sounds like in the patent realm, you can, if you track it carefully enough, where you come up with your technical problem that you have the answer to, and you can sort of separate out the human intervention from the AI intervention. Do you do the same thing in the copyright side?
Right, and so that's where it gets super tricky, because we're talking about, again, this sort of mix with humans and the machine and the human input that goes into the tool. So the Copyright Office looks at it this way. They say, well, look, a human might be sitting there at the keyboard typing in a prompt, and that's human innovation, but there's really no link, because of the way the technology works, between what that human puts in as the prompt and what the creative choices were that were made to create the output. And so unless a human has made a creative choice that is more than de minimis, is the term that the Copyright Office uses, although there's no guidance on what exactly de minimis means, you know, it's not going to be protectable. And so we tend to see protection just like you would see with a derivative work, where you start out with an original copyrighted work, and then you might build upon it and make different improvements or modify it in some respect. There's copyright protection in that those modifications. There's also copyright protection in the selection and arrangement of various images. So for example, you know, there was a comic book author that tried to obtain a registration for the comic book as a whole, and the Copyright Office said, well, you know, you used AI to generate these images, so the images themselves are not copyrightable. We won't give you protection on that, but you did, as a human, curate the way that those images appear in the comic book, and so we'll give you protection on that. So it is a form of copyright, albeit a little bit thinner than a traditional copyright, but it does exist.
Which leads to a question for Puya. If you use like, a chat GPT or some Gen AI to help draft claims or help understand the technology in a patent, does that impact the patentability of whatever you're disclosing?
It's actually it's been a month, February 13th, the USPTO issued guidelines on this. So there needs to be, the human needs to make a significant contribution to be deemed an inventor. So if I have the bright idea of making a water bottle that has a Bluetooth speaker integrated into it, and I just tell ChatGPT, make this for me, or tell me how to make this, I am not the inventor. I just simply came up with the idea, but ChatGPT or any other Gen AI gave you the solution to it. Now, if I take that solution and I fiddle around with it and add some and realize that it was wrong or I can make it better, then I'm an inventor. Then I made a significant contribution to it. So there needs, and this is modeled after when, let's say you and I have an invention together and you tell me, hey Puya, I want to make this water bottle with a Bluetooth speaker, and then I do all the work. Are you an inventor to it? And the answer is no. We both need to make some type of significant contribution. So it's modeled after when there's two or more inventors, people working on a project, who has made that contribution to it. They've also clarified other issues as to, is the owner of the generative AI system, for example, OpenAI, they can't be deemed an inventor. If you've trained the model in a specific way, let's say you're trying to find a new chemical composition and you've generated or you've trained a generative model in a specific way for that, then you might be deemed an inventor. So the guidelines do shed light on this.
Let me transition slightly and just, we've read in the news about these lawsuits against OpenAI, and they're generally based on copyright, my understanding, and I don't know if there's anything on the patent realm on that. Lauren, what do you think the impact will be of those suits, if any? Or is this just the knee-jerk reaction of society to new technology that has got to be something evil about it, so we need to stop it?
Well, it's interesting. And as I mentioned, there's always been this tension between copyright law and the internet allowing these trolls out there to come and steal from other folks, and how to balance that. Because again, you want this creative dialogue, and the AI tool is essentially, in a lot of ways, I think, doing what what humans do as they're creating something. I mean, you can't unknow all of the other things that you've read in the past or seen in the past. They maybe just do a better job of compiling them and summarizing them and helping you come out with a different output. So I think it's going to be interesting to see whether the lawsuits have legs, because currently they do not. I mean, reading the tea leaves, so the lawsuits involve risks that are associated with basically using copyright protected content to feed into a generative AI tool that will then train the AI tool how to think. And so the plaintiffs in these suits, they're famous authors. Sarah Silverman has headlined one. The author of Game of Thrones is involved. And what these authors are saying is, you took this stuff and you copied it. Admittedly, you took a copy of it and put it in your system to train it. And that alone should constitute copyright infringement, they say. And in addition to that, whatever comes out of it is necessarily based on what you put in it. And therefore, the output is infringing too. But the thing is that copyright law as it exists today is designed to be a little bit flexible in terms of allowing this balance between using other material as source material and not outright copying. And I think that's what we're seeing here is the plaintiffs have been shut down so far by the courts, which say, well, the output looks nothing like the input. Surely, it's going to be considered fair use to potentially use that stuff to train the tool. And it doesn't necessarily have any impact on what that output's going to be at the end. The AI tools are confident that this is the outcome they're going to receive based on the case law we've seen to date. If you guys remember the Google Books case, in that case, there was a big lawsuit over whether Google could take copies of copyrighted novels and post portions of them online for public consumption. And the court ultimately found that that was totally okay. It was transformative use and it was for the betterment of the public good. And I wonder if a similar outcome, if we will see a similar outcome here.
On the patent side, do you see any issues with, arising right now for you from the use of AI, sort of similar to, the lawsuits we've seen against OpenAI?
There's no issues now. I think potentially now with the new guidelines, the issues could be, 10 years from now, if a patent is in litigation, it might come up as, was AI used to invent this invention? And can you prove that AI was not used for this invention? So there might need to be, inventors need to start documenting their use of it. It'd be a good idea. And practitioners need to start asking this question when it's coming down to inventorship. So we always give a list, or, you should be giving a list and saying, these are the inventors. Can you verify that each person contributed to this? Now you should be asking, are these inventors, did anyone contribute? And did you use AI? And if so, in what capacity? Because then you need to figure out the inventorship if it's correct. So companies should be putting out new guidance for their inventors to document their use of AI, and that needs to go into the record. So then later on, if this comes up during litigation 10 years from now, 20 years from now, you can answer it.
You just anticipated where I was going to go with this, which was what should companies be doing, or law firms as well, in terms of providing guidance to, in our case, the lawyers in the firm and other personnel in the firm, and in the case of in-house counsel employees, regarding not just the use of AI, but the tracking of that use. I mean, I understand, I guess, on the patent side, would you be recording prompts and how you got to the solution? Would you go down to that kind of granular detail?
I think you may, the guidance isn't clear, but I think you might need to. It's a good idea to show that, I asked generative AI to help me with this, equation or explain something to me, and that's the extent of what I did, but I didn't ask it to invent everything. It might come down to that. I mean, if you're using a closed system, it doesn't save your prompts, so that's another issue. For example, Copilot doesn't save. I mean, it doesn't keep the history. If you ask it one question, then you ask it the next question, the previous question isn't there before. So you might need to mindfully keep saving your prompts. I would say yes, but I think the guidance isn't completely clear yet.
What do you think, Lauren? I mean, in terms of if you've got, let's say, employees who are hired to create and use Gen AI in that process, what kind of record keeping would you recommend from a guideline perspective?
So that is sort of an open question on the copyright side as well, but we're seeing a lot of clients grappling with these issues because when you're using an AI tool to generate content, you don't have any visibility into what data set the tool used to learn how to do what it's doing. In general, Midjourney, one of the image generators, grabbed some headlines recently because a list of authors got published that they supposedly have source material in their system. But in general, there's no requirement that they disclose. So you have no idea where any of this stuff is coming from. Maybe it's in the public domain, maybe it's been licensed, but you have no idea. And so until the lawsuits regarding whether use of that material without permission would impact, whether it would create liability on the back end when you're creating content, all of that, since it's undecided, there's a benefit, I would say, in I think making sure that you're documenting everything that you're using to the extent that you're able to use a closed universe. We've had clients that are building their own internal builds, AI tools, so they have a specific knowledge of exactly what goes into training it, so they know that there's not going to be infringing output. But that's not necessarily, I guess, a realistic option for everyone. And I think it also poses some additional limitations, such as, you're not going to maybe get as creative or interesting of an output if you're limiting what you put in on the front end.
Let me ask a basic question, because we've been using the terminology in either one of you. What is a closed system, a closed AI system?
So you're controlling the universe of source material that the platform has. And so that can be beneficial from a number of respects. I'm just speaking right now from a copyright perspective, but Owen and Rebecca talked earlier about, data privacy issues and potential leak of privileged information. All of that stuff theoretically should be controlled if you're creating your own in-house closed system.
Yeah, if you, for example, if you use the free version of ChatGPT, your prompts can be used later on to train the model, and that can lead to data issues, patent disclosure issues. The closed system, for example, our version of Copilot, is your prompts will not be saved to train the model later, and so therefore you can put private information into it.
So what is used to train a closed system?
Other material that's out there, for example, the issues that are causing the copyright cases, other people's works, not your work.
So if you adopt like a closed system Copilot or something, it has been trained on the same information that the open system of Copilot has been trained on?
Yes, right? But my understanding. But then
it won't be trained on what you're inputting into it.
Correct.
Because that was going to be a question I was going to ask the two of you, whether there is a risk of, it's one thing to say it's closed, therefore we can put client confidential information into it, but we have lots of clients. So is there a commingling question that could arise, which could arise both in the copyright and patent context, if you're using a closed system?
It could, if you're using that. There's models out there where, for example, it can train on every document that the law firm has, and then it gives you the output. So that's a closed system if it's trained only on your data. But then that creates a commingling question that you just brought up, and client, you need your client's permission to say, can we train our own model on your data?
Let me ask, because we're getting close to the end of, I'll say, this portion of our discussion, and then we'll spend a couple of minutes at the end with everybody. In terms of providing guidance to employees, do you have any generalized tips as to what should go into guidance? And I've prefaced this with my own biased view that we lawyers tend to tell people what they can't do. Don't do this, don't do that. That's kind of the way we look at the world. So I have a slight bias as to how you would draft these guidelines, but I'd like your input on that. I'll start with, I don't know, Lauren.
Sure. So I've been grappling with this issue myself because, as I mentioned, a lot of this stuff is not protectable, and what you don't want is a competitor using the same exact platform and putting in a same or the similar prompt and getting the same output. You can't really then control it. That will even affect your search engine optimization results and confuse consumers in the larger scope of things. And so I think what I always tell clients is to be very careful about adding some sort of human element to it. That might be, as I mentioned before, maybe you start with an image that the AI tool generates, and you add your own illustrations on there with Photoshop, and maybe you even put a proprietary trademark or brand name on that image, because if that's used, that's can be trademark infringement. We have the Getty Images lawsuit in Delaware is dealing with that issue right now, where watermarked images were used, and they're suing both on copyright and trademark infringement theories. So those are some ways to protect. And I think if you have policies in place to require your employees to, I guess, operate under certain parameters that you've deemed okay, and you take whatever steps you can to create enough, I suppose, additional human content to the AI generated material, then it is something that's protectable. And then to that extent, you can obtain copyright on that and theoretically prevent against others using or misusing that material.
Do you have any thoughts on how to prepare guidelines for employees?
So, I mean, I think.
Go.
Oh, sorry, go ahead, Puya.
I'm gonna do a shameless plug and say we've actually helped clients on this. We've helped with guidelines, do's and don'ts for generative AI. One of the do's is use it in based on your company policy, but it also depends on if you have a closed system and an open system. If it's a closed system, you can put confidential information in it and help it create your within the parameters of significant contribution, your inventions. If it's an open system, use it for general editing, improving your work. The use cases we brought up of helping with blogs or titles to articles, but just be mindful of the final output. The final output isn't a touchdown. The final output gets you to the 20-yard line. You need to take it from the 20-yard line to the end zone.
And I would say do some level setting with the employees on the front end. I mean, to your point about lawyers always telling people what they can't do, people are going to be using this stuff, just like people use social media at work when you have policies against that. And so you got to build that into what you're doing and just think about realistically, from a business perspective, like what are the risks and benefits of using this stuff? I've had some clients that have said it's just not worth it. We're going to, ban AI for right now, but I don't know that that's the right answer because I think this thing is coming. I mean, even if the plaintiffs were able to prevail on these infringement lawsuits, it's not going to stop people from using these tools to create content. It's just going to create some sort of a licensing, compensation, or permission scheme.
All makes sense. Well, we're getting toward the end, so let's do this. Let's bring back Rebecca and Owen. And while we're doing that, Sadie, if you can tell people what the code is.
The CLE code for today's program is SS9821. Again, that's SS as in Seyfarth Shaw, 9821. Thanks.
So first of all, I want to thank the four of you. I mean, this has been an absolute pleasure preparing for this and presenting today. I want to end on sort of the usual, I don't know if it's usual, but what keeps you up at night regarding AI? And what are you anxious about? And what do you think is a good thing about it? And what are you looking forward to? And I will start with Owen.
Well, I will start with what excites me first, and that's the prospect that this technology is going to get better and better, and I think it's going to make our practices more efficient and help us deliver better results for clients. So I'm really excited about that. What keeps me up is the notion that AI, the way that it's set up, it's sort of programmed to get us the results we ask for, but it might do that in ways that we don't expect. And I think we have to be prepared for that. And again, I go back to that case from last summer where lawyers had these fake cases from ChatGPT, and they said, please give me cases that support this position. And ChatGPT gave them exactly what they asked for. It just happened to be that the cases weren't real. So I think we just have to be very mindful and go into this with eyes wide open about what the risks are and making sure that we keep a close eye.
Oh, yeah.
The efficiency that it's going to make us more efficient and better output if you know how to use it correctly. So that kind of ties into what keeps me up at night is, 60% of people were only using it in another survey, half the people are using it. It's the people, the great quote is you're not going to be replaced by AI, you're going to be replaced by someone who knows how to use it properly. So that's what keeps me up at night is we have people who are barely using it and people who are using it a lot. So until we get onto that level playing field, that's what keeps me up at night. And the people who aren't using it might be the ones that are making the policy, and that might end up in the wrong policy.
Rebecca, what keeps you up at night?
I mean, what keeps me up on it truly is Skynet and the malevolent use of AI by individual humans who can wreak ridiculous havoc. But setting that aside, What I'm excited about is its ability to clear out the noise for me, and particularly where I am in my career, I want to do more strategizing and problem solving. And so if AI allows me to get rid of the smaller stuff or make that a lot more efficient and opens up the more fun stuff, that would be great.
And finally, Lauren.
All right. I think, similar to what everybody else says, I think I'm excited about all of these possibilities and creating this additional tool in an artist or creator's tool belt. I don't think it's going to be all that different from, the advent of photography and use of a camera. I think this is sort of another one of those tools in the tool belt. And I think it's going to be really interesting to see the way that it's deployed. I mean, I'll be so bold as to say I don't think that copyright law is going to change all that much, even at least in the near term. I think people are going to find their way around this, and this is going to be fair use and ultimately end up promoting creativity more so than restricting it. And in terms of what keeps me up at night, I think those deep fakes and just this idea that, this content that gets put out there that people assume is real. And we have government agencies regulating stuff to the extent they can to protect the public, but I feel like it's always a step behind. I think about social media influencers, and the FTC has all kinds of rules on that, and you have to use specific hashtags and stuff to alert people to the fact that this is a paid, product placement situation. We don't have that for AI, and I don't, sitting here today, can't think of an easy way to implement that scheme, and so that's really scary to me in terms of protection of the public.
Well, thank you, everybody. And like I said, it's been an absolute pleasure, and I hope for the audience that this was helpful to you, and we look forward to seeing you on April 11th for our next one.